Good afternoon, everyone, and good morning, Shuai. Thank you so much for being us, and welcome all for joining us today. So my name is Yuemin Yan. I am assistant professor at Chinese University of Hong Kong Faculty of Law. I'm very pleased to chair and monitor this session, and our distinguished speaker, Dr. and Professor Shuai Guo from Beijing, China, and so the topic of our seminar today is about cross-border insolvency. But before I move on and I hold over to Professor Guo, please allow me to have a brief introduction of Professor Guo to all of you. So Professor Guo is an assistant professor at School of International Law, China University of Political Science and Law in Beijing, China. But currently, he's based in Rome, Italy, as a consultant at International Institute for the Unification of Private Laws, UNIDROIT. He holds a doctoral degree from Leiden University in the Netherlands. He was a visiting scholar at the University of Texas at Austin in the United States and a consultant to the United Nations Conference on the Trade and Development in Geneva, Switzerland. So he's the author of 4 books, with the most recent one being Recognition of Foreign Bank Resolution Actions, published by Edward Elgar in 2022. He also has various publications in various leading journals. I'm very pleased to welcome Dr. and Professor Guo. And for today's seminar, we are going to have 1 hour in total. So Professor Guo is going to present for around like 50 minutes, and we reserve 10 minutes for Q&A, given that we have a large number of participants today. So if our participants have any questions, please do send me your questions directly through the chat box, and I will pass these questions to Professor Guo in our Q&A sessions. So without further ado, let me hand over to Professor Guo, please.
Thank you very much, Professor Yan. It's my great honor to be here, and very glad. I was surprised by the large amount of audience today, and nice to meet you, everyone. I'm going to share my screen. I hope that could work. Sorry for a moment. Is that working?
Yeah.
I think so. Right. Thank you so much. Like this. Okay. All right. The topic of my presentation today, as Professor Yang has just introduced, is about cross-border insolvency between the Chinese mainland and Hong Kong. As also introduced briefly earlier, my research is mostly about banking and financial law, and as well as corporate insolvency law. And since today we are meeting here, once again, thank you so much for the Chinese University of Hong Kong, which I guess most audience from Hong Kong, so I chose this topic. I hope will be interesting for most of our audience. I'm going to, yes. A brief topic, but I think I got from Professor Yan that most audience here are lawyers. Probably you have known about this, but maybe students as well. For those who are not very familiar with national or cross-border insolvency law, just a basic background introduction of what international insolvency law deal with, some fundamental doctrinal thesis on this is 2 theories that are contradictory with each other: territorialism and universalism. For the first one, territorialism means that a bankruptcy proceeding will only accept the fact and insolvency proceeding within the jurisdiction where the proceeding is opened. This is mostly in the ancient times, as you understand, when there are only like the initial idea of sovereign state, we do not want other sovereign state to interfere with domestic matters. So also within the bankruptcy proceedings, if a company or person is bankrupt, we want this court within restrictions have the sole power to deal with the assets of that bankrupt. So that company or that person is under the full jurisdiction of one certain court. But if there are like assets outside that jurisdiction, basically our jurisdiction will say, okay, hold on, and this is going to be our sole jurisdiction, and your home jurisdiction have nothing to do with this. This is a general idea of how it was treated in national insolvency during like the early times. But with the expansion of international business and global asset allocation, the territorialism will become more inefficient, as there will be multiple parallel proceedings, and also it creates this inequality between different creditors. So it then gradually came up with the new universalism principle, which maintains that insolvency proceedings should have worldwide effects. And this is something which is much more catering to the needs of globalization, multinational corporations, and that is something most scholars are embracing and advocating today. However, the reality is, even with this idealism, universalism, it is very difficult to implement the principle in reality. The reason for this impossibility, as I think is very obvious, because states, we are still living in the era of sovereign states. They want to keep control of their internal matters. So if there is one proceeding, which means it must have extraterritorial effects outreaching other jurisdictions, so that will be a problem for the receiving jurisdiction. And find a middle way. Namely, there could be one global insolvency proceeding, but there could be also local proceedings to meet local needs. However, of course, the global proceeding has international effects and could be recognized in elsewhere, while local proceedings generally only has the effects within that territory. So based on this modified universalism, the UNCTAD, United Nations Commission on International Trade Law, as part of the United Nations Legal Office, came up with the UNCTAD Model Law on Cross-Border Insolvency. We call it MLCBI as insolvency lawyers, 1997, and gradually developed the Guide to Enactment and Interpretation, 2013. So this is the most important international instrument in the national insolvency field, which has 4 pillars, that is access, recognition, relief, and cooperation coordination. Basically, access means a foreign proceeding or foreign representative, that is like administrator or a liquidator appointed by a foreign court or authority, can have the access to ask assistance and relief from the other court. That means access. And recognition and relief is intertwined. It's similar to the private national law recognition enforcement, but we use recognition relief in international insolvency fields. And those are like 2 intertwined concepts. Recognition means the receiving jurisdiction will recognize a foreign proceeding either as a main proceeding, which has international effects, or as a non-main proceeding, which we saw this like territorial effects. And if we recognize something like a foreign proceeding, then we need to provide some relief. That's what international insolvency law needs. And those needs are ranging from different matters. Could be, most importantly, under the model law, is about the state of domestic proceedings. So some assistance could be given to the foreign proceeding or to foreign representatives. Also, some jurisdictions adopted and could allow additional relief, such as we give access to the foreign representatives to come into our jurisdiction to collect some data, collect some documents, managing and calculate the assets, or even transfer the assets outside the territory. So that's a different reliefs under different laws, but that's mostly discretionary under different national systems. and that's the controversial part as well. The last point is about cooperation coordination, which requires the courts, administrators with administrators, as well as courts with administrators cooperate and coordinate together. And that is something very important to cross-border insolvency cases, as you can picture that most large, complex national cases would involve various jurisdictions, multiple assets, millions or even billions of stakeholders involved. So that really needs the cooperation coordination of different courts and administrators in this process. So basically, that's the four cornerstones of the ancestral model law. And built on this, it could be other issues and jurisdictions. Since it's the model law, so jurisdiction could adopt the model law with some revisions to the original text. And I have listed here a picture. That's the web page of the ancestral model law. And on the website, if you're interested, you can search for more resources such as the cloud, which is a data base for all the cases, digest a case law summary of like key cases, leading cases, and as well as practical guide and judicial perspective. So basically, the first model was the most important one, and I'll come back to that immediately afterwards. That China and Mainland has been, as well as Hong Kong has been working on cooperation coordination, also learning from the model law on some key terms, such as COMI. I'll touch upon it after. But since it was adopted like 27 years ago, it was quite ancient, I must say. And there's a lot of other new issues that have been being touched upon by the old model law. So in 2018, there came out with a new model law on recognition and enforcement of insolvency-related judgments with guide to enactment, which deal with that's something that matters that hasn't been dealt with within the old model law, 997 model law. The reason has this model law is because a UK Supreme Court case, Rubin versus Euro Finance, which does not which did not recognize a New York judgment with regards to avoidance actions. Basically, avoidance actions is not clearly prescribed in the 997 model law. So the UK Supreme Court says, as the UK has adopted the 997 model law, but it thinks avoidance actions is beyond the scope of the 997 model law. Therefore, the decision was based on common law principles. To solve the problems of these insolvency-related judgments, the answer then came up with the new model law and requesting states to supplement the original model law and have a more efficient way to deal with insolvency-related judgments. And also, the 2019 also came up with a third model law on enterprise group insolvency guide to enactment, which, according to the title, deals with more complex group problems. And this is about more procedural coordination of different jurisdictions to have a more harmonized and efficient way of dealing cross-border enterprises. Of course, there are much more to those three model laws. And there are several jurisdictions that the UK are actually thinking about adopting the second and third model laws. But that is not a topic of our today. And if you are interested, of course, you can search for more information on our website showing here. And then I'll get to the main point of today's presentation. And of course, since I'm a Chinese lawyer, I came from the mainland part of China. I believe we are much more interested in how the mainland will deal with foreign, including Hong Kong. I use Hong Kong, including Hong Kong, insolvency proceedings And that's something I think quite a lot of cases are going on right now, including Evergrande, just last month. I will touch upon later. So how the Chinese system is dealing with and how the Chinese courts and judges will react to those requests. So starting with the legal basis, which is Article 5 of the Chinese Enterprise Bankruptcy Law, also listed the year here, 2006, almost 20 years ago. So there, at that time, there were not so many cross-border cases, but we had one provision trying to cover the problem that is Article 5. And Article 5 has two paragraphs, basically. The first paragraph means saying the procedures for bankruptcy which have been initiated according to the present law shall have binding force over the assets of relevant debtor beyond territory of the People's Republic of China. It means a Chinese proceeding must have extraterritorial effects, and theoretically, a Chinese court can reach out to assets located outside China. But of course, this request would be need to be recognized and assisted by foreign courts. So, but that sets out the basic principle of Chinese law. The Chinese law also kind of in line with the universalism or universalism principle in this regard. However, when receiving requests, we can say when an illegal effective judgment ruling made by foreign courts involves and that is within the territory of the People's Republic of China, and the debtor applies with a request to courts, a People's Court to confirm or enforces that when a Chinese, a mainland court receive a request to recognize and enforce a foreign insolvency proceeding, what the court should do. And the court shall, first, according to the relevant international treaties that China has concluded or ceded, or according to the principle of reciprocity. That's two preconditions: one, international treaties, and second, reciprocity. And there's an active condition, that is, those proceedings cannot violate the basic principles of the laws of the People's Republic of China, does not damage the sovereignty, safety, or social public interest of the state, and does not damage the legitimate rights and interest of the creditor within the territory of the People's Republic of China. So those are, we can easily understand as public policies, and those are negative conditions, and those public policies cannot be violated to some extent. So basically, for any foreign insolvency proceeding to be recognized in China, that would be a little bit difficult. First, you have need to two preconditions, and you cannot violate those public policies. I list some practice after 2006 version of Article 5. They have discussed a little bit about those conditions listed in Article 5. There are 5 cases listed here on the screen, and you can see there's a gradually opening up of Chinese attitudes towards foreign insolvency proceedings. So first, in 2011, there was a case involving a creditor, that is Shuai Fund versus the Lehman Brothers. We all know the start of the global fund crisis in 2008, and also led to a lot of litigations afterwards. But in that process, the Chinese creditor also brought Lehman's UK subsidiary before the Shanghai court, and the Lehman made a proposition that because it already entered into insolvency proceedings, so it should be handled by sole insolvency proceeding court, and those assets should be transferred outside the territory of China. But the case was actually solved by agreement, mediation in any way. But there were some legal discussions about At that time, China would not recognize a foreign proceeding because there was no international agreement between China and the UK that was against the UK subsidiary, and there was no reciprocity. Back then, China adopted a very strict reciprocity test. If a foreign jurisdiction hasn't recognized a Chinese judgment before, a Chinese court will not deem that a reciprocity had been existed. So back then, there was no cases between China and UK, so there was no reciprocity existed at that time. So also around same year, 2009, 2011, there was the Beitai Hong Company, that the company from Hong Kong, also was seeking recognition in the mainland. That was in Beijing, but this case finally went up to the Supreme Court, and the Supreme Court gave opinions on how to deal with the problem. So the Supreme Court said there was no basis for recognition of foreign insolvency proceedings. So let me go back a little bit to the text of Article 5, which the recognition is given to judgment. Well, in this process, insolvency is always different from normal civil or commercial law judgments, because in insolvency proceeding, even though it's like a lot of orders could be written like a document, but it's an ongoing process. And recognition always comes with additional reliefs, as I introduced before, like allowing foreign representatives coming into our territory to collect the documents, collect the assets, meeting with creditors, etc. things. So not only about monetary or other enforcement matters, but a long ongoing process, a very long process. So at that time, I think the Chinese court's opinion was there's no basis for recognition of those kind of proceedings in that regard. But starting from there, I think China, the judicial branch, academics, and other lawyers are thinking about we are in the 2010s, there are quite expansion of Chinese companies, and they also came up with a lot of issues with cross-border insolvencies. There's any financial distress that need to be restructured or even liquidation. So that's something really a need for Chinese court to think about how to deal with this kind of cross-border request. So there was a new, later, not a new, but also 10 years ago, but 2014, that was included in the Supreme Court regarding cases like Sino Environmental Technology Group Limited, Singapore versus some Evertech Group, Fujian Corporation Limited. So this was also a case from Singapore about recognition of foreign insolvency representative, that was a Singapore judicial manager. And back then, just a few years after the Beitai company, it was difficult to recognize a foreign insolvency proceeding. However, the court came up with a new strategy that using the general private national law, that's our conflict laws, law applicable to other laws, and they ruled that a foreign insolvency representative, a foreign insolvency practitioner, can be deemed as the legal representative of a company under the corporate law principles. And then this insolvency representative could conduct exercises as a legal representative in China. So that's a way to circumvent the actual problem of international insolvency law, but find an alternative solution to address the issues of cross-border insolvency. But still, then Article 5 was not discussed in that case. Only until 2021, that is, again, another Singapore court, Singapore Xinghe Holding Company, they used Article 5 in IFRS bankruptcy law to directly address the issues of cross-border insolvency. in that time, international insolvency proceedings are interpreted included in the judgments, and Article 5 could directly apply in that case. And since Singapore has recognized, I will come to that later, recognized Chinese bankruptcy proceedings before, we believe that there was reciprocity existing before that. So that was like a direct application of Article 5. And most recently, last year, this is a case of Beijing recognizing a German insolvency proceeding in Rennes. And the particular about this case, that of course it's the first insolvency law case relaxing the condition of reciprocity. So in this process, in that case, reciprocity was deemed to have been established since the law in the German law has certain provisions to recognize foreign proceedings, even though there were no actual cases from Germany that had recognized the Chinese insolvency judgment before. The reasoning is that theoretically, a German court could recognize the Chinese insolvency proceeding based on a German provision in the German bankruptcy law, and there is no case indicating that a German court will refuse to do so. That presumably they established a legal reciprocity between China and Germany. So that's the case, the reasoning that the Beijing judges used in that case. So, but that's also along the general trend of Chinese development of private national law, of relaxation of the condition of strict real reciprocity, and turning into a little bit to legal reciprocity. Also, the Shanghai case recognized in English courts judgments applying legal reciprocity, along with the general development of that period. So, but that's also a very important development in insolvency as well. So basically, if a jurisdiction has some laws recognizing foreign proceeding and could demonstrate that it has no cases refused to recognize Chinese judgment before, we could presume a legal reciprocity exists, and then we use this legal reciprocity as a legal basis to recognize foreign proceedings. Apart from that, we also have that several negative conditions and public policies, but according to my research, there has no cases using that again. This is generally because public policies as interpretation method should be interpreted very restrictively, and of course are inclined not to apply public policy too broad. I think that's we accept also in China, also internationally as well. So that is cases received by Chinese courts, but there are also Chinese insolvency proceedings that were recognized elsewhere. So I have listed 4 just to give the audience a little bit idea of how it was dealt with. So they're starting from 2014 in Zhejiang, Jianshan, Guangdian, Toll Point photovoltaic cases recognized by Bankruptcy District of New Jersey in the US. And there was 2019 of Luowai in the reward science technology industry group was also recognized in the US, but as bankruptcy court of Southern District of New York. And also the 2022 one of Huacheng, DNE Huacheng Energy Corporation was also recognized in New York, the same court, bankruptcy Southern District in New York, in the US. Also the 2020 about the Jiangsu Shuntian Chuanbu, the matter Santee Marine Development Corporation. That was a case recognized in Singapore in 2020. That's why I just mentioned before, the judge believed that there was a reciprocity already existed between China and Singapore. So even with, if we were to apply the real reciprocity, restricted reciprocity test between China and the US, as well as China and Singapore, there had existed established reciprocity. But since we have developed a little bit more relaxed conditions a little bit last year already in Beijing in 2023, we can say that most jurisdictions have some cross-border insolvency could be deemed as having reciprocity towards China. So that's the development for China and foreign jurisdictions. And for China, Hong Kong, that is a much more close relationship. Of course, we have a lot of business with Hong Kong, and a lot of Chinese companies are listed in Hong Kong, using Hong Kong as an intermediary holding companies to establish or other financing purposes. So that's really a lot of connections and close ties between the mainland and Hong Kong. That's why in 2021, the Supreme People's Court and the Hong Kong Special Administrative Region reached this record meeting on mutual recognition of and assistance to bankruptcy insolvent proceedings between the courts of the mainland and of the Hong Kong Special Administrative Region. I think some of our audience must be very familiar with this cooperation now. And afterwards, the Supreme Court issued opinion on taking forward a pilot matter relation to the recognition of and assistance to insolvency proceedings in the Hong Kong Special Administrative Region. On the Hong Kong side, there were the procedures for mainland administrators' application to the Hong Kong SAR Court for recognition assistance practical guide. So basically, these three documents consist of the whole cooperation arrangements. The record meeting is actually general principles guidance, does not provide on much of the concrete guidance. The procedure I will just mention, there were three documents within the cooperation arrangements. And of course, you should look at the second one I list here, the Supreme People's Court's opinion that has in total 24 provisions, specifically regulating the issues between mainland and Hong Kong cross-border insolvency. Compared to Article 5, this is really a big development, because that's gives a lot of concrete guidance for Chinese judges in particular to how to deal with these matters. So a brief recap of what is going on in this new opinion. So the Supreme Court selected three trial cities to implement the opinion: Shanghai, Xiamen, and Shenzhen. The reason of selecting those cities are quite obvious. Of course, those are the cities that are dealing with most of the cross-border insolvency cases. But of course, the rationale or some legal provisions would affect other jurisdictions as well. For example, Beijing, as I mentioned earlier, in 2023 case, using the term economy, I list here on the fourth line. This is a term especially established under international insolvency law, and that is something very particular, also new. The first time that was appeared in the Chinese law is about this kind of Supreme Court opinion. So even Beijing is not selected as a trial city. The judges in Beijing would also look at the documents and use some of the terms or rationales or some guidance in the documents and opinion to guide their judicial making process. So that's really actually beyond the scope of selected cities. And Hong Kong proceedings that could be recognized in the mainland China, including browsing, winding up, credit one-to-one wrapping, a scheme arrangement. I think you're much more familiar with that. I'll keep that. And that the eligible Hong Kong representatives that could be recognized in the mainland are liquidators and provisional liquidators. And coming down to some substantive rules, the first one, as I've been repeating this term a lot of times, COMI, that is center of main interest. You can understand it as like alternative of incorporation. So basically, there's a presumption that a foreign proceeding can only be recognized if it is opened in its place in corporation. But we understand there in the contemporary business structure, there could be a lot of letterbox companies that even where it registered not have a lot of economic activities. So we use alternatively the term center of main interest to decide what center of main interest are within the jurisdiction. For example, in the opinions, center of main interest could be consider several factors, including the place of principal office, the principal place of business, the place and principal assets, etc. of the debtor. Also about the creditor's knowledge about the debtor's operations, the debtor's project and financing matters, and many financing creditor, etc. There are quite a lot of factors that could be taken into consideration to determine what the real economic connection of that company is, where that is. So on this basis, COMI is the term to cover all these kind of different factors, and you can decide one particular proceeding in international insolvency cases. Actually, in some Hong Kong cases, the judges have already also using the term COMI instead of the original place in corporation to have more freedom to interpret or find the real connection of a company, where the real connection is. And some additional articles about what kind of documents you must submit, but as you can read it. And after you submit some recognition request, there will be automatic stay of recognition for stay civil actions, arbitration involving the debtor in the mainland, or procedures for execution will also be suspended in mainland. Apart from that, the Hong Kong representatives could seek for additional reliefs, just as I mentioned, such as taking over the property, seals, account books, documents, and data the debtor, or investigating the financial position of debtor, or preparing some financial reports, deciding internal management, deciding the day-to-day expenses and other necessary expenditures. Could also decide to continue or stop the debtor's business, disposing the debtor's assets, representing the debtor to participate in civil litigations, arbitrations, or other proceedings, or receiving the declaration of claims by creditors in mainland and examine them, or performing other duties that the People's Court consider necessary. So, so that's quite a lot of examples of Hong Kong representatives are being recognized that they could do in the mainland part of China. And also the law, the opinion is quite emphasizing the cooperation, which is also very important in international insolvency. So cooperation is an ongoing process because all insolvency proceedings needs a long time, and that's cooperation includes both from the administrators from both the mainland and Hong Kong, as well as courts from the mainland and Hong Kong. The last one is about public policy, similar to the Monster Model Law, also similar to Article 5, that if some public policy is violated, those proceedings will not be recognized. Those public policy includes not a COMI is not in Hong Kong, or was recently relocated to Hong Kong within 6 months. That's like foreign shopping and as like a modified mono shopping with bad intention. So that's something we do not want. Does not meet the requirements of Chinese bankruptcy law, the conditions for commencing bankruptcy proceedings. Does not have equal treatment for Chinese creditors, or there's fraud, or there are other circumstances where the People's Court consider recognition assistance shall not be rendered. So that those are basically also there were other principles and or the law of public order or good morals. If they were violated, the people can decide not to recognize it. And that's generally the provisions of Article 18. But as I mentioned before, personally, I believe the court will be very cautious in applying Article 18 public policies. According to the previous cases, there was no in insolvency proceedings, and also internationally. It is common practice that court will restrict the application of those public policy exceptions. So after the promulgation of the record meeting and also cooperation arrangements, the Shenzhen court had recognized a mainland liquidation proceeding as the Samsung paper. So the Hong Kong court first requested recognition assistance on 20th July 2021, and a few months later, on 15th December 2021, the Shenzhen court granted recognition. So you can find those cases online, and that was quite easy case because the situation was quite clear. The Samsung paper is a company registered in Hong Kong, has conducted business in Hong Kong for more than 40 years. Its assets are mainly located in Hong Kong, and so the court decides that the whole mill was in Hong Kong and could be recognized, and afterwards, the Hong Kong representative can ask for additional reliefs. But there are also several other cases. We don't know how this is going. Next, Hong Kong court has requested for Zhaoheng hydropower in 2020 to Shenzhen. Also, Austin Water International Holding also to Shenzhen in 2020. Also in January and in April 2022, a freshwater national group was recognition request were requested to Shuai. But that's more complex cases. We are waiting for the results. And a last slide shows some cases from Hong Kong. So also immediately after the reach of the record meeting, the Hainan Airlines restructuring was first recognized in Hong Kong as a recognition proceeding from mainland. So, you know, Hainan Airlines is a large airline company involves a lot of subsidiaries, over 300 subsidiaries. In that regard, it's a very complex one. Also, two very controversial ones about Peking University Founder Group, Tsinghua Union Group. There is the first decision, several decisions, appeals, and also on substantive issues. So the result is those proceedings are recognized, but not all the reliefs are granted. The relief was seeking by the foreign representative, that is the representatives of Peking University Founder Group and the Tsinghua Union Group, are to stay additional Hong Kong proceedings. But of course, the reason those that were not given those kind of reliefs to the Beijing, those representatives, of course, the contract, underlying contract of those claims were chosen by parties to be governed by English law and subject to sole jurisdiction of Hong Kong courts. The Hong Kong still thinks the Hong Kong can decide on the matters of the amount of claims, but of course it has no power to enforcement. All the assets are located in the mainland. So basically, we are waiting to see how those cases are going to develop. Since the decisions of the Hong Kong court will still need to be recognized in the mainland part of China, and we are waiting actually, how the Beijing judges will react to those actions. And also from last year, that was a quite easy one. A liquidation proceeding was recognized about Guangdong Overseas Construction a case. And also, I just mentioned at the beginning, last month, I think the Hong Kong judge issued the judgment against the China Evergrande Group and starting a liquidation proceeding. And also, there were already schemes arrangements, I think, in both Hong Kong, Cayman offshore jurisdictions. But that's been going on for quite some time, and there's no results that was achieved, I guess. So I think that's the reason additional proceeding was commenced in Hong Kong. But I would say, to be honest, there was no bankruptcy proceeding in the mainland part of China yet. So the question would be, what the consequences or what are the other implications of that cases will be. So immediately after, I got a lot of requests from some friends. I would say, would Chinese court recognize Hong Kong proceeding like that? So basically, to me, it still goes back to the original idea of international insolvency law. So everything could be based on the current existing architecture and national insolvency law. And we have adopted a comprehensive 24 articles of opinions that can help the Chinese judge to deal with it. And the most important thing is to decide and POMI. As I said, the decide and POMI is alternative incorporation. So what we really need to examine what the POMI is if the Chinese court decide that the overall group's POMI is in the mainland China. It has sufficient legal basis to refuse to recognize Hong Kong proceeding. But we will treat those companies separately, and we do not overthink or mingle all the assets of business together. We just treat every single entity separately. We still think if a company is registered in Hong Kong, is listed in Hong Kong, dealing with most Hong Kong investors, Hong Kong could be its center of main interest, and therefore, based on this kind of concept, a Chinese court could recognize that. But I must confess, this is still an ongoing process. I don't know how the Chinese judges will do it. Personally, I'm in favor of international cooperation, but let's wait and see how the case will develop in the future. So that's basically what I would like to share today. I look forward to any questions. And thank you so much for bearing with me with this kind of thing. And if you have any questions, I'm happy to be reached out by the email provided here. Thank you very much. I'll give the floor back to you.
Thank you, Shuai. Thank you so much for this wonderful presentation. I think it's quite informative, interesting, and also updated. And thanks for including the most recent, the updates. I think most of the participants here are really interested in those kind of recent cases. So I've collected some very interesting questions, and I grouped them into two categories. One is at the normative level. So one question is that, so you've presented that about the cross-border recognition of the case and proceedings, but to me or to some audience, the scope of the proceedings is a bit unclear, because in one insolvency proceeding, it involves various documents and judgments as well as the arrangements, right? So for the recognition and enforcement, which kind of documents or decisions are sought for recognition?
That's a very good question, a very cool question. And that's why there was the distinction of several model laws, as I mentioned in the beginning, several model laws. So the most important document or decision we try to recognize is decision to commence an insolvency proceeding. And that's definitely insolvency proceeding that needs to be recognized. And based on this order, so normally in this order, it will say company is bankrupt and proceedings commenced, the court will appoint an insolvency representative, and the representative is allowed to blah 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 a lot of things. And a request was sent to the other court saying, we have a commenced proceeding, we have appointed official representative for that company. Please recognize this proceeding and assist our foreign representative to, in your jurisdiction, to do things like staying the assets, collecting the data, collecting the assets, sort of thing. So that's the most important one. But of course, in the whole process, there could be a lot of other judgments. So that's the reason why there were debates about whether those insolvency-related judgments should be recognized within the whole overall scope of insolvency proceedings. So, for example, in the United States, I think they adopted a quite broad concept as including all these insolvency-related judgments within the discretionary power of the judges. So, basically, if if there exist insolvency-related judgments as avoidance, there must be insolvency proceedings opened. That on the most that the proceeding will be recognized. Then it comes with the question whether to recognize other related matters, such as getting back the money of avoidance transactions, actions, and so under the model, there are quite a release that could be given to foreign representatives, and the U.S. said, okay, on one of the decisions, we recognize the avoidance judgment of a foreign proceeding, but as I mentioned before, Rubin versus Euro Finance case, that it was not the case, and the UK Supreme Court said, okay, that is not within the scope of the old model law. So that's also the direct reason why there was a new model law on insolvency-related judgments. So basically, simply wrap up the thing, the most core issue is commencement of insolvency proceeding. But of course, apart from other insolvency-related judgment, really depends on Tristan's side whether they would like to include it in the overall scope of insolvency proceedings.
Thank you so much. So a second question is about the legal status of submitting of records. I think the question from the audience is about like Hong Kong and mainland China. So the participant asked that the meeting of records, it seems to the participant that this meeting of records is much less formal than the arrangement of reciprocal recognition enforcement of general civil and commercial matters, which came into effect in the form of ordinance and Supreme People's Court's interpretation. So the audience is wondering and also curious about the legal status of meeting of records.
Yes, I think you must know a lot about Chinese law, and that's absolutely right. According, legally speaking, the meeting record is just like guiding principles of that. It does not have any binding effect as from the legal perspective, but I must say, in practice, since it's a document, and also the record meeting is an agreement reached between the Supreme People's Court of China and the Hong Kong Special Administrative Region. But apart from that, there's a Supreme Court opinion. So that is a lower hierarchy of the legal letting. But I must say, like, lower courts would actually follow the rules issued by the Supreme Court. Just in practice, I think that most judges would do that way. And a very interesting, I would mention one specific question. So Article 23 of the opinion says that in the course of hearing cases cross boundary insolvency assistant courts, in pilot areas shall promptly report to and seek guidance from the Supreme Court on mirror issues. So basically, every course will be reported, and now this is written very clearly in the opinion, and that's actually what is practiced about. So they will ask the opinion of the Supreme Court. Of course, I think the Supreme Court judges who actually wrote those guidelines will stick with what they have wrote, and they will decide more or less according to the rules.
Okay, thank you. So I have a few questions here, so I'm going to speak very briefly. So another question is about the Evergrande case based on section 327 of chapter 32. So the audience is to ask, do you think the cooperation mechanism can increase the likelihood of Hong Kong courts to wind up a foreign company which has operating subsidiaries and assets in the mainland?
I believe that is the intention of the leaders of both the mainland part of China and Hong Kong to actually to strengthen the financial status of Hong Kong, to make Hong Kong courts have access to the assets located in China, not only Evergrande but also other companies as well. So I think that's the idea of helping Hong Kong maybe become the only jurisdiction nowadays to compete with other jurisdictions, for example, Singapore, to maintain the financial status. That's if you want to have access, especially in the global structure, if you want to have access to Chinese mainland's assets, you have to go through Hong Kong. I think that's the idea. It's just in practice, I think we just need to give some time to our judges, to the mainland judges, to ask them to learn and process and ease their doubts about the effects of recognition. I think the intention is there. Just give them time, theoretically, it will be done in that way.
Okay, thank you. The last two questions about the practice. Do you predict if Chinese courts will recognize other foreign insolvency decisions other than Hong Kong? And the related question is that if mainland courts refuse to assist the Hong Kong insolvency proceedings, will it lead to a winding up deadlock?
First question is yes, because we have done that already last year, as mentioned in the Beijing court. That was the case of Beijing court recognizing a German proceeding. So obviously that's quite recent, and that's a signal showing to the outside world that China is embracing or waiting to accept international insolvencies, also helping the Chinese business to gain favorable reciprocity in administration. Well, that's the reason I thought. Basically, I think China is much more willing to accept or find alternative ways to accept, such as using the foreign judgments as evidence or as a supporting document to support the administrators, or like Beijing administrators work in that way. I doubt that we'll actually issue a very hard no to foreign stock proceedings, but probably there will be other alternatives to help. As I said, cooperation and communication could be also a way to deal with these issues. I think my personal feeling is quite optimistic, and in the future, I think Chinese, and also the need and the reality requires Chinese mainland to much more embrace and open the market for national insolvency. I think that's pretty much all I want to share.
Okay. Well, thank you so much. Thanks again, and thanks everyone for being with us.